Hi, I'm Anna Denton Jones of Refreshing Law Limited, and in today's session, I want to talk about appeals. Now, often when I advise employers that as part of any process, such as a disciplinary or a grievance or even redundancies, that they need to have an appeal stage at the end, often I sense there's a reluctance perhaps to have to put another layer of process into something that may have already taken quite some time. So, why do we have to have an appeal? Well, it's all part of following a fair procedure from unfair dismissal perspective, and there's actually case law that agrees that an employer can actually correct, for example, procedural mistakes that have been made along the process up until that stage at the appeal. So I would actually urge you to view the appeal stage as a really good opportunity to correct any holes that there have been in things so far, and to almost pull the rug sometimes from under the employee's feet as regards some of their arguments. If you can hit those arguments head on in the appeal and show perhaps that whilst something may be capable of being criticised, actually it wouldn't make any difference to the outcome, then more the better, really. The ACAS Code of Practice, which the Employment Tribunal will take into account when they're judging fairness under Section 98(4) of the Employment Rights Act, refers specifically to this right of appeal. So again, for that reason, we want to include it. If the employee doesn't actually raise an appeal, then if you were challenged later in tribunal, you would have the opportunity to argue that they should receive less compensation. A tribunal can deduct up to 25% of the compensation that they're going to give to somebody for failure to appeal if they agree that that was an unreasonable thing for the employee to have done. So certainly if I'm acting for an employee, I'm always going to argue that they should appeal. So who needs to deal with the appeal? Well, if you look at the ACAS code, it always refers to somebody who's been impartial, not involved in the process so far, somebody who's more senior. Arguably, it's going to be fairer if it is somebody who is genuinely a fresh pair of eyes looking at something. So it might be worth appointing somebody from perhaps a slightly different team or a different division rather than just the more senior manager who could be seen perhaps as just going to rubber stamp what's just been said. But that isn't always possible, and it's not always possible to have somebody more senior. Sometimes it has to be somebody who's a sort of sideways move on the corporate structure. So who else should be at the appeal? The employee should be bringing somebody to accompany them if they wish. The statutory right to accompaniment does apply to the appeal stage. And what we're going to do at the appeal, well, there's kind of two routes we can go down. One is what we call just a review, which is really where the person who is conducting the appeal looks at the information that was in front of the decision-making officer at the previous stage and decides whether or not their conclusion was reasonable in the circumstances. Sometimes, particularly if things have gone wrong along the way, we may want to go deeper and actually do what's called a complete rehearing. And that will involve perhaps the appeals officer interviewing both the decision maker to understand how they arrived at their decision, but also the original investigating officer, and perhaps even questioning witnesses if they think there are some gaps in what's happened before, and really hearing the whole thing over again, giving the employee full opportunity to say whatever they want to say. And certainly whenever I've been in tribunal, the tribunal will ask the appeal person which of those two routes they've gone down. Was it a review or was it a complete rehearing? In terms of the outcome that's possible, unless you've got the contractual right, so written in your contract of employment, that on appeal a more serious sanction can apply, you won't be able to, for example, turn what was a final written warning into a dismissal. There's been a recent case on that, Macmillan versus the Airedale NHS Trust is the name of that case if you want to look at it. Sometimes new evidence will come out at the appeal stage. Sometimes the longer a process goes on, the more comes to light. And certainly if the appeals officer is going to take into account something that wasn't put in front of the employee at the original meeting, then they will need to give that employee the opportunity to comment on it before they take it into account in their decision-making process. Obviously, I'm going to suggest that you keep detailed notes of what goes on at the appeal stage, so that if you are challenged, that you've got that information to back up what's gone on. If you do have any questions about today's session, please do send me an email. It's adenton@refreshinglawltd, all one word, .co.uk. Thank you very much.